Hi, I'm attorney Karen Ulmer, and I do divorce law and wanted to explain the process when you come to an agreement. So, if you come to an agreement, or even if the judge had to enter an order, the agreement's going to be called a marital settlement agreement or a property settlement agreement. They mean the same thing, it's just a different terminology used depending on who's writing the agreement up. Or in some cases, you'll have a court order where the judge has decided how to distribute your debts, your assets, and if there's going to be alimony. So when you're getting divorced, in order to resolve your divorce, you're either going to have a court order or an agreement. And in that agreement, it's going to detail what happens as far as the distribution of your assets and debts, and if there's going to be a term for alimony. And that's the roadmap that you're going to follow when you get divorced. The judge isn't going to actually do the transfer for you. Your lawyer is not going to do the transfer for you. It is up for the parties to transfer the house or to transfer the bank account, or refinance, depending on what the terms are that are in your agreement. But sometimes parties don't do what they're supposed to do. And so you may still need a lawyer and the court's assistance in order to implement the roadmap that you've been given in your marital settlement agreement, your property settlement agreement, or your court order. So you do have rights. For example, if your agreement says that you received the house and that your spouse is going to transfer the deed, but they don't do that. If that happens to you, you need to pick up the phone and call an attorney, and the attorney can draft a petition to the court to force your spouse to transfer that deed to you like they said they would. Another common situation is where an agreement says that your spouse is going to pay you for the house and they're going to refinance and give you the money in a certain amount of time. Some typical time examples would be 60 days. When that 60th day comes and you don't have your money, you need to file a petition for enforcement with the court. These are the type of cases that a court will often award attorney fees. While you were going through your divorce, you might have thought you could get attorney fees because you made less money or for whatever other reason. But courts are not usually generous in awarding attorney fees when you're going through your divorce because you both generally are paying lawyers. But when someone violates a contempt, and they're in contempt, they violate a court order or a marital settlement agreement, a judge is more inclined to award you the costs of going to court and the costs of the attorney fees. So if you need to enforce your order, you need to contact an attorney and we'll be happy to assist you with that. And if you're faced with a petition for contempt or enforcement, know you run the risk that you will probably be assessed attorney fees. And the best thing to do would be to try to cooperate. Even if you can't refinance your house in the 60 days that the agreement says, the best thing you could do is to make a good faith effort and communicate with the other party. Try to come to a modified agreement to give you more time if you can. But the best thing would be not avoid your obligation, but continue to try to communicate and resolve it with the other side.